all my case.
Yes.
Thank you. On reflection, my lord, I'm not going to pursue the Article 8 side of the appeal. Could I, however, make one additional point on the Article 6 side?
Yes, of course.
In answer to the point that was raised at the outset today. Could I please hand up a copy of Section 31 of the Senior Courts Act? I know the
Yes.
court will be very, very familiar with it.
Whilst you're waiting for that, does that mean you're formally withdrawing Ground 2 Article 8?
Yes.
Thank you.
Thanks so much.
Now, before I turn to Section 31, the decision under challenge was the director's review decision that was identified by the judge below. Could I show the court that decision, which is in the core bundle at page...
Are you here explaining to us what the ramifications are of your withdrawal of Ground 2 and Article 8?
No, I'm explaining the ramifications if I win on civil right.
Right, okay.
And if I may begin with the decision under challenge in the claim for judicial review. So this is tab 14 of the core bundle.
Sorry. Tab
14. And then the review decision, which was the decision under challenge, is at page 120. And if one looks at page 121.
So just take it, I've read these, but document by document. The first one is the letter of the 13th of September.
Yes, but the court may recall that there was a debate at the hearing below whether the operative decision was the decision of the 13th of September or whether the operative decision was the review decision, which is at page 120. And in light of the structure of the regulations, the judge below accepted the appellant's submission that the only decision to consider was the review decision. And so I'm going to just show you, I'm not going to show you what's at 118, I'm just going to show you what's 120, because it's that which properly forms the decision under challenge.
And it was a decision, what? Refusing a request to grant legal aid. Because we need to see what the application was, but that was the decision, the request to, the refusal of the request for legal aid.
Yes, and it amounted to a fresh consideration of whether to grant legal aid pursuant to Section 10 of LASPO.
Right. So this I'd like to look at a bit more closely. It's the 31st of October 2022.
Yes.
Just give us a moment. So the civil right point was the headline barrier.
Exactly. And so if one looks at page 121, it's the paragraph beginning accordingly. So in light of the analysis of the A1P1 case law, the director concluded that there was no civil right, therefore unnecessary to consider whether the appellant would be able to present her case effectively without legal aid. That said, I remind you that Article 6 can only be engaged where there's a dispute. So there were two, I accept that there were two hurdles for the appellant, one civil right, two dispute. Now, in terms of a challenge to that decision, in my submission...
Sorry, I keep speaking over you, but I'm just catching up with this neck of the information. That by this stage, yes, so there had been an, yes. So at this stage of the Windrush application, there had been an application but not a review/appeal.
Yes, that's right.
Okay. So at this stage there had only been an application put in, and that was what was known then.
Yes, yes.
So I've now put myself back in the.
I'm not dissenting from anything that the court observed this morning. I'm just going to look at what the consequences are. Now, a challenge to a Section 10 decision, in my submission, is not limited to a claim that the decision gives rise to a breach of a convention right. It is open to a claimant in judicial review proceedings to impugn the lawfulness of the decision with a view to obtaining a quashing order, and the decision being, if appropriate, if there's still anything at stake, sent back to the director for a new determination. And to give the court an example of that, could I please show you in the authorities bundle, tab 41.
Well, wasn't that the one that went to appeal?
It did go to appeal, but there was the bit that I'm particularly going to show you wasn't overturned. And it's page 1474 that I wanted to show you.
But what was the actual subject matter of the judicial review claim in this case?
You'll get that from the paragraph I'm going to show you. Page 1471, paragraph 73. This is one of the claimants, the claimant called IS, and he was seeking legal aid in reliance on his Article 8 procedural rights for the purposes of making an immigration application, an application for leave from the Home Office. The director had made a decision that he didn't need legal aid to be able to make an effective application. It was done on that limb. And one sees at paragraph 73 that Mr. Justice Collins concluded that the director's analysis was wrong in law. Mr. Justice Collins didn't consider it necessary to go on and to decide whether, without legal aid, there would be a breach of Article 8. Instead, he quashed the decision. That was the relief that was granted for the unlawful Section 10 decision.
The problem that I got is this. So Section 10 says you must make an exceptional case determination if it's necessary to avoid a breach of convention right. And if you can't be sure that it's necessary or not, according to Guidavenci, you decide the risk. Now here, the request was for a determination. It was refused because it wasn't a failure to give legal aid, wouldn't give rise to a breach. And indeed, that's correct. We know that because you accept that it doesn't apply. That refusal went to the review person in the legal aid agency, and that person said for two separate reasons. One, civil right, which may be wrong, and two, that there's no dispute. So his decision that you're not entitled to legal aid under the determination of exceptional thingamybobs is correct. Part of his reasoning is wrong.
I agree.
His decision is correct.
I agree. Can I work it through, if my lord would bear with me for a moment? I entirely accept that analysis. What it means, if I win on the civil right point in this court, what it means is that there was an error of law in the review determination, but it made no difference.
No, there's an error of law which wasn't material because the decision was
Which was immaterial.
so you don't get into discretion. His decision was to refuse the review. The reason why he refused the review was because you don't qualify because there's no breach and not any likelihood of a breach. Part of the reason why he thought there was no breach is wrong, but it doesn't matter because it had to be there will be no breach in light of your concession that it doesn't apply at the application stage.
Yes, well, the way I was going to analyse it was on the basis that it made no difference. And what I was going to show the court is Section 31 (2) capital A, that on the basis of my concession, Section 31 capital A clearly bites.
But there's a lot of case law that says it's not just capital 2A. There's a lot of case law that says the question is whether or not the decision is unlawful, and if the error is not material, the decision isn't unlawful. But if there has been illegality, but you can satisfy the 2A test, that's come up at least 3 times this year in this court. And the fact of the matter is the decision is not to overturn the refusal to give legal aid, and that decision is correct. Part of the reasoning is wrong, but it doesn't matter because it would have been refused in any event.
Well, the submission I was going to make, my lord, was that it would be open to a claimant to bring a claim for judicial review challenging the error of law in the decision. The claimant would be caught by 31(2) capital A, but the court would have a residual discretion under 31(2) capital B, nevertheless to make a declaration.
But he doesn't challenge an error of law. He challenges a decision, read section 54(1) of the CPR. The grounds upon which he challenges it are that errors have been made. Here it is said 2 errors occurred. Well, here it said 2 things were done, one of which is an error, the other of which is not.
Yes.
As a result, the decision is perfectly lawful. The thing the review person should have done was to dismiss the review request. He did that, albeit that some of the reasons that took him there were wrong.
Yes. Well, if that's the analysis, then I'm limited in the way that I tentatively suggested earlier, which is the appeal is dismissed, but I respectfully ask the court to make findings in the course of its judgment to the effect that there was a civil right.
Could you just set out what the alternatives that you see face us in terms of disposal of the appeal, just clearly? So I think I've understood what they are, but I prefer to hear it from you.
The 2 options that I'm advancing are: option 1, allow the appeal, although the error could have made no difference.
Sorry, before you reason it, allow the appeal and do what?
Allow the appeal and make a declaration that the appellant's claim for compensation was a civil right.
Okay, and
option 2, dismiss the appeal, but make a finding in the course of the judgment to the same effect, that the appellant's claim for compensation was a civil right.
what is the difference between those as you see it in terms of the precedential effect of anything that we say?
It's I think the precedential difference would be that the declaration would be binding, but
But only on the parties to this court claim, only on the director and Mrs. Ogie.
Well, it would be the ratio of the cause.
That's the
If
same.
you take your second version, it's over.
Exactly.
But a declaration that it's a civil right, we don't really do that. There's a Court of Appeal authority saying you decide whether things are unlawful and in the context of the Human Rights Act.
Well, the declaration is not the important bit for the reason that my lord just identifies. The important bit is allowing the appeal, and that the essential reasoning of the court is that the appellant had a civil right. That then is binding on lower courts.
But refuse any other relief.
But refuse any other relief. Refuse to grant any relief.
You have quite a lot of other authority which we haven't even touched on, which says that isn't what we should normally be doing under the Human Rights Act or generally, and that the road for this court is to determine whether or not the decision under challenge was lawful or not. And the decision under challenge was to say you can't get civil legal aid, and that's lawful. Part of the reasoning wasn't. That's the difficulty that I have with it. What you really want to do is get a an advisory declaration, almost like nothing against those, which you want to use in other circumstances.
Yes, well, that is the alternative. Could I just, I entirely accept that where one has a claim for a breach of convention rights, then following misbehaving in all of those other cases, it doesn't matter what the reasoning of the administrative decision maker was. What matters is whether or not there'd be a breach of convention rights. In my submission, the exercise under Section 10 is slightly different from that, because it's not simply a binary question of breach of convention rights or not. The director under 10.3b, if I've got the numbering right, is broader than that. The director's got to consider the shape of the
You've got to consider
proceedings as a whole, analyse risk, and so
no risk here, because we know, because you've conceded that it doesn't apply. You come back to the same problem. It's not just if I've got a civil right, everything flows. It's if I can get over 3 hurdles. We haven't even touched the third one. Do you need legal aid? But you know you've lost on the first one, and it's the second one that you're arguing about. And put it differently, is the decision of the review director unlawful? Is it wrong?
well, we come back to the point which I think I've accepted. It contains an error of law, but the outcome was correct.
But the refusal of legal aid was correct.
On the basis that it was put. Now, it might have been differently put and said, please can we have legal aid for the first step and for the review step?
Yeah, but they didn't.
We didn't.
Anyhow, your invitation is that to the extent that it's proper for us to do so, having heard argument about the right issue, we should say something about it in some way, because otherwise every applicant will face the same problem of catch-up, which is that they either can't review things as quickly as the scheme is administered, or they have to get involved in continuously adding grounds as they go along through the scheme or something of that sort.
And there are cases that say you can just give a judgment, you don't have to give any relief. You can just give a judgment. You
Yes.
talk about making a finding, but you can give a judgment, and you can phrase it in such a way as to say maybe it has to be dismissed because of A, but not because of B, and we haven't considered C.
Yes.
Yeah. Okay.
And I hope it's clear that the footing on which this appeal is brought is to establish that one thing. Could I just turn my back for a moment to see whether I've addressed that adequately? Thank you very much.
No, thank you very much, Mr. Butler, to you and those with you. Yes, Sir James.
Well, can I start with that no dispute point? Let's start within the judgment at paragraphs 44 to 47. There's the common ground, but we might as well summarise it at least. The judicial review here is of the decision, and it's a judicial review challenging the lawfulness of a decision to refuse ECF for her application for compensation under the Windrush Compensation Scheme. We've given, I hope, hopefully, the various dates on which the various bits and pieces occurred in our skeleton. If you have that, page 48 in the core, take you to the relevant paragraphs. From paragraph 21 and following, there's my order that section. So we've given you the dates there. And in summary, the decision to refuse ECF at that stage was made on the 13th of September 2022. And there was then a review and a confirmation of that decision, as you just looked at.
But on the by the look of it, that nothing turns. I mean, they're read together and they say the same things.
They do, essentially. And just to give you the dates, it was a
Yes, exactly.
reprise, as it were, and the final decision, therefore, was on the 31st of October. That's the one you looked at a minute ago on call bundle page 120, on the basis that Article 6 wasn't engaged because of no dispute and because of civil right. The claimant nevertheless made the application on the 19th of December of 2022, and she did so with the voluntary assistance of her solicitors. And again, that may be of some interest if one ever gets to the third, what might be called the third element under Article 6, which is whether or not breach was their compliance if it's engaged. But we're not involved with that here at all. There haven't been arguments about that or findings about that. But then on the 31st of January 2023, after that application had been made and after there'd been a refusal to provide legal aid at that stage, the application was made for a JR of that decision to refuse ECF, 31 January 2023, and on paragraph 24, you have the references there, again, I hope helpfully. So the short point is that it is that decision that is the subject of these proceedings and this appeal. And the judgment below at paragraph 44 held that at the time of the decision to refuse ECF in that way, there was no dispute. And it's now accepted correctly that there was no dispute then. And for reasons that I will come to in a moment, we submit that's the end of the matter. That's the end of this appeal. There was a suggestion that I think...
40, it's interesting, he says, the next issue to consider, assuming contrary to the conclusion I've reached, is there a dispute? Are you saying that's technically obiter dicta? I suppose everything else that follows from there.
It is technically, because dispute has resolved it. But it's now said, just to go back to dispute if I may, that there was a dispute at the internal appeal stage. That I think is a reference to what's called the Tier 1 review, which you've probably seen reference to. That was applied for on the 10th of January 2024, almost a year after the JR had been launched. After the claim for compensation had been refused on the 15th of December 2023, and this is 25 and 26 of the skeleton, you see the dates there. But that was applied for only about a month before the hearing, that issue was raised about a month before the hearing of the claim in the administrative court, which occurred on the 20th and the 21st of February 2024, or a little while before. And there was a spat, if I can call it that, below as to whether or not that additional issue could and should be added in, with a pretty strong position being taken on our side that it should not be. And if you wanted the submissions that were made on behalf of the Director of Legal Aid at that stage, I don't know if I can turn it up now, but can I just simply give you a reference, which is Core Bundle, page 271. The point I simply flag at this stage is that there may even be controversy about whether or not there was properly what would be called a contestation or dispute, even at that stage. There hasn't been any real argument about that substantive issue, and there hasn't been any finding about that substantive issue. But that may be a question of controversy in its own right. But we don't get anywhere near that, because the actual decision under challenge was the decision that I've identified.
Can we just add something into the sequence, which I think we saw before?
Yes.
Which is the application notice of the 18th, 19th of January. That was seeking permission to rely on the witness statements and to raise a supplementary issue. Is that the process by which I have it at 230 in the core bundle? I may be wrong, but was the applicant claimant at that stage, as it were, trying to push the judicial review on into the review process, or I just want to understand exactly what this was all about?
Yes, I think it was. You see, it's dated the 18th of January 2024.
Well, just after they'd been knocked back.
difficulty that I have.
Yes, just after we've been knocked back
Yes,
and
I
just before the JR.
Yes, I'm at the moment I'm not trying to work out whether this is a good thing or a bad thing.
No,
I think
we're
I just
trying
want
to
to
get the dates.
understand
I think
what was.
the sequence, I think, goes 15, 12, 23, refusal of the claim for compensation.
Yes.
10, 1, 24, Tier 1 review applied for. In other words, they apply for review of that decision. Attempt to make this application and introduce that 18, 1, 2024.
Yes.
Hearing of JR, I think 2021, 1, 24.
Yeah, and our skeleton argument that you took them to was the 13th of the 2nd, which is our response to that.
The problem that I've got is if you read the application notice, there are two difficulties. Well, there are three difficulties with the application notice. Secondly, there would have had to have been an application and a decision by the Secretary of State about, by the Director, about the Tier 1 review. They might have decided that there is or there isn't a contestation, and they didn't apply and they didn't get a decision. They didn't apply because they thought there was no point, because the Director would say, well, I've already told you, I don't care whether there's a contestation, it's not a civil right. So they didn't apply for it. But that is the fact, they didn't apply for it. And secondly, given that there was no challenge because there was no decision, it's hard to see what supplementary issue they would raise. The proper thing to have done would be to get a decision and apply to amend in accordance with the practice direction of the case law, but none of that happened.
Make that application, exactly. I mean, one can do all of that, but for present purposes,
It's not there. And the third difficulty is I don't actually see whether or not the application was ever granted or refused or dealt with.
no, well, it doesn't.
You seem to think it wasn't necessary to deal with it, again, because whether or not there was a contestation, the judge didn't think there was a civil right. But what there has never been, it seems, is a decision on the review to refuse legal aid for any reason, because there was no request. It would have been refused, we think, for at least one reason. Whether it had been refused for reasons 1 and 3, no contestation, and by the time of the review, whatever the problems before, you don't need legal aid at the time of the review.
Yeah. But the fact of the matter is, we are where we now are.
Yeah.
I just wanted to not as a to lay down a marker that we're not necessarily accepting that dispute would have existed even at that time. That may be
no, but you're saying we shouldn't rule on whether or not the review stage is a contestation and whether there needed to be legal aid at the review stage. You're saying both of those elements of Article 6 shouldn't be looked at by this court. Is that what you're saying?
That is what we're saying. Sorry, my lord.
No, could we? You're getting it in stereo. But could you just explain why, at a point where you'd made an application, you'd been told no, and you were seeking a review, why at that stage it would not be a contestation? Because the whole point of the legal aid is to be there at the beginning of a process rather than after it's finished. So, if you apply under the scheme and you're told for this, that, and the other reason you don't, you're not going to be given any relief under the scheme, and you then apply for a review. Is there an argument that that's not by then a contestation?
Well, my lord, you might have that argument. It slightly depends on what stage of the process you're in, and whether that stage of the process amounts to a sufficiently firm and fixed decision, as it were.
Well, in a sense, one's thinking that if at that stage it hadn't amounted to a contestation, well then, if that is a criterion which is absolute, then, as it were, you're never going to get Article 6 support for lawyers at this stage, because you can always say, well, it isn't disagreed enough.
My lord, listen, I perfectly accept that there is a perfectly decent case that can be mounted to say that there is a dispute.
But by that stage there was, but you're not conceding it. That's the point you're making.
Yeah.
That's all.
Okay, understand.
That's all. So we are where we are,
Yeah.
and the question is, what do you do now? And the difficulty that we confront is the difficulty that was perhaps exemplified by the exchange you had after the short adjournment, which is that there is, I'm afraid, a degree of making it up as my learned friend goes along. The problem that you've got is that if there is no dispute, and if it is accepted as it now is that the decision was lawful, it doesn't matter, for all the reasons that my Lord Justice Lewis put to my learned friend, but it doesn't matter whether or not there was another part of the decision making which may or may not have been in error. There is a fundamental distinction between immaterial error, brackets no unlawfulness, and some other species of error that does sound in unlawfulness, but may lead to the discretionary application at the relief stage, or the mandatory application of section 2 capital A in section 31. But the premise for section 31 capital 2A, as you will well know, is unlawfulness. It's a remedial point. It presumes unlawfulness, whereas the immaterial error accepts no unlawfulness. And so what you've got is an inevitable dismissal of the appeal. And the question that then arises is, well, despite that fact, should this court go on, and it would necessarily be obiter, one can characterise it in various different ways, but should this court go on and start opining on the meaning of civil right in a case like this? If it were to do so, or if it were to be invited to do so on that basis, then no doubt one should have had a whole series of authorities that would have helped you on advisory opinions, yes or no, academic issues, yes or no.
But wasn't that for you to bring? I mean, it wasn't that for you to bring.
No,
I mean, I noticed that we weren't given Salem and all those cases, but
I'm not going to die in a ditch over who should have raised it, but you haven't had those debates. If my learned friend
what I'm saying is that if you're right about what you're saying now, and that they were inevitably going to run into this buffer at a very early stage in the argument, then if it was the director's position that at that point that was it, and
that's what we said in our skeleton.
But take us to the point, and also for us to understand in that case why has the civil right issue been so fully argued one way or the other during the course of both the proceedings below and here?
Because it was argued below because no one knew what the answer was going to be on point
that
one.
I get.
It was argued at this level because the points have been raised at the permission stage, and as you'll recall, Lord Justice Arnold simply said, sufficiently arguable to amount to this, to raise a realistic prospect of success or whatever it was without more. I'm not taking a point on who should have raised this, but you would have to confront whether or not that was an exercise that the court felt it was sensible or appropriate or advisable to do.
If it's a pragmatist, couldn't you have a judgment like this? There are lots of things you need to answer in order to find out if there's a breach of Article 6 and whether the decision was unlawful. One of the things we'd have to consider is whether it's a civil right. Answer, seen for this moment, yes, it is a civil right. However, that doesn't resolve the appeal because there are other things you have to prove. Legal aid was necessary. Brackets, we haven't got enough evidence about that, so we put that into another box. At the moment, all bets are off. And then you get to the next section of the judgment and says, but they will lose on this point. Why isn't that enough to say that you've got a judgment there which gives guidance? Because that used to happen quite a lot in the old days, and that'll achieve the same as the declaration. And that's really what the case is about, is that they want an authoritative judgment from a court as part of the reasoning as to why it was unlawful.
This is not a submission of jurisdiction.
No.
The court can do anything it wishes. but in order, all I'm simply trying to lay out is that in order to go down that route, in circumstances where everyone accepts that the dispute point is the first point, it's a short point, it's a dispositive point, and it is now conceded, it would be a device to then go on and say, right, we're now going to opine on civil right in the judgment. And you don't get anywhere by altering the order of the issues. You still have to confront whether that's an appropriate thing.
Part of our reasoning and therefore binding, because we'd have started, but we'd have said there's a number of things, and it would be part of our reasoning.
Yes, but quite often a court will do that at first instance because it doesn't know whether it's going to be upheld or undermined on appeal in relation to a prior point. One can see the good sense of that. But here you've got a point which is plainly dispositive and has been accepted of the very issue. You don't need, therefore, to go further in relation to Article 6. There's nothing you can't.
That. The argument is of a different nature, which is that this matter has been argued below. It's been decided against the applicant in this case, and consequently, although it may be obiter, it stands there in the way of future applicants, potentially. And that this applicant has brought it before us and is entitled to an answer. I mean, really, that's the that's the situation. It doesn't mean we have to provide an answer, but if we considered that the overall justice of the situation meant that an answer was a reasonable course to take, then it sits there for what it's worth in due course. That's the position you're as it were you're responding to, as I understand it.
I don't want to nitpick, of course, but the claimant or an appellant in this situation is not entitled to any answer. The appellant has to get to the stage of the analysis where the answer that he seeks is relevant and survives, and it doesn't do so here. That is not to say the court can't go on and decide that, but it will need to think about whether or not it wants to issue an advisory opinion. And there might be a series of factors that would suggest that isn't a terribly good idea, or may not be a terribly good idea.
Well, you'll tell us what they are as you
It
go
might be
on.
thought to be better, is my submission, to wait until there is actually a live case before you, where the issue truly does matter.
On your analysis, there's never going to be a live case because, I mean, there'll be an argument about even at the review stage whether there's a contestation. I mean, this will take...
Which I might win and I might lose.
Yes.
And if I lose it, we'll have to have the fight about civil rights.
Yes, and in the meantime, X hundred of people, let's say, will have been through the scheme, getting the same answer from the director.
Well, my lord, you have no evidence to support any number of any description. Quite often under Salem, as you know, the numbers of cases
No, I was only going
irrelevant.
the numbers which I think are in the evidence before the judges to the number of people that were expected to be involved in the scheme and the number that have been so far through the scheme and so forth. So one sees the sort of scale.
You see the scale of people going through the scheme.
Yes, that's
it
what I
doesn't
mean.
follow that you end up with this issue being live in all of those cases. It just depends, and particularly if you're going to get sucked into debates around which bit of the scheme might or might not constitute a civil right for present purposes, it might be as well to have a live case in which the issue was actually live and actually mattered, and where the judgment of the court would amount to.
In relation to the other limbs, in relation to breach and so forth, perfectly understand. And also, it may very well be that your current client, as it were, is not equipped to look at the broader picture, or because of the scheme that was set up by the Home Secretary, which involves other forms of help for applicants and so forth. So I quite understand that we may be short of information to deal with matters of that kind. But the issue of whether this is a civil right or not is not going to change. It's going to be the same today as it will be in a year or in 5 years.
Well, there is theoretically the same headline issue. Of course, I accept
Yes,
that.
but and so if the gatekeeper of public funding for legal aid has got a view which may be right, maybe may not be right, and is always going to apply that view, as no doubt she would, then that's important.
Can I
Well, it's important if the court is ruling in a way that creates a proper resolution of it in a real case which is live. I don't wish to go around in circles. You have the point.
Can I ask a very simple question?
My experience, they never turn out to be simple. Those questions.
Well, there's two possibilities. Either you're saying to us as a court, we can make up our minds whether or not we want to say anything, or you're submitting that we shouldn't say anything. Which is it?
The latter. My submission is you should simply dispose of the appeal. And if you want to determine the civil right issue, or any court wants to do that, it does it in a case where it is still live, where it actually makes a difference, and where the court's ruling will be binding and can be treated as ratio by other courts.
And although you haven't brought the stacks of authorities which talk about advisory judgments and things like that, you're inferentially relying upon them.
I am. I mean, it's ex parte Salem, which my lord referred to, which is extremely well known. But they tend to focus on the reluctance of the court to start giving advisory opinions or entering into hypothetical issues. They focus on how many cases are truly likely to be stacked up behind it. Where is the public interest in the court going down this road, recognising, as it may have to, that its judgment would only be over if it were issued. And then it may also focus on whether or not there would be factual nuances in relation to the potential answers to this claim, so that what it does is to traverse the field and genuinely provide a useful answer. Now, as I made absolutely clear earlier on, this isn't a jurisdictional issue. The court can do these
I mean, one of the things that does bother me, actually, it's quite easy to decide in the abstract if it's a contestation and if it's a civil right. It's much harder to decide in the abstract whether legal aid was necessary. And if it's just the review stage, one would need to know, because a lot of the reports are about the whole thing. If it's just the review stage, one would have to stop and think, well, how much will they have already got out of the process by the stage of the review. So I wonder whether we can deal with all three necessary parts anyway.
You certainly can't deal with the latter part.
You think we can't?
My submission is you definitely can't. You haven't got any findings of fact below in relation to that, in relation to that compliance issue.
Yes.
And one can see a whole load of arguments that might have to happen at that stage. I mean, if one goes back to the Guadavici tests and asks whether the person could properly and effectively present their case and so on, if that's the essential issue, which it is in that light of that Court of Appeal authority, then you'd have to take into account all of the facts, the fact that they were able to submit an application, they were able to get voluntary legal assistance at that stage.
So
You
we
might
can
even
never
enter into Brian
decide,
territory.
We can never decide that this was a breach. One, because it's accepted that it wasn't a breach and we can't do the Part 3 compliance. So you're saying the only thing we should decide is whether or not we should give a judgment about civil rights, which won't answer the ultimate question and can't alter the outcome of this case.
You don't need to do it in this case because the claimant
It's not about this case.
has received the money. It isn't about this case. No, the debate we're having is about the utility
Yes.
of the court going down in whatever form any of these roads in relation to this issue alone. But I do accept the point that my lord essentially makes, which is that the importance of that might be diminished if you can't do all of it, even on the facts of this case. But I've made my submissions about that. I wanted to start on the on the assumption that I do have to have a fight about civil rights.
Yes, tell us about civil rights.
Tell you about civil rights. I'm very grateful. So civil rights, the basic tests we now have very clearly set out by the Grand Chamber in a case called Grazida. That's if you have your authorities bundle to hand. That's tab 23. So it is quite important to bear in mind perhaps that this is Grand Chamber about Article 6, civil rights and all of that, in 2022, so some considerable time after Vols and all those cases, but this is Grand Chamber, and we'll see in a minute, relying on a whole succession of Grand Chamber decisions leading up to it and confirming them. And if you go within this, the facts don't terribly matter, it's just the general approach that I'm after. But if you go in the judgments to page 803, and you look at the bottom, you will see under the heading the court's assessment, you know the structure of the European Court's judgments by now. Can I invite you to read for the basic structure of this Article 6 set of issues, para 257. So that's 257. So you've got the various limbs that you're aware of. There's got to be a dispute, one. It's got to be about a right which can be said at least on arguable grounds to be recognised under domestic law. And that can be about do you actually have a right at all? Or how does that right apply to you on the facts, as is made clear in the second sentence. And then the things we're not concerned with here, directly decisive for the right in question. That sometimes arises in different contexts and whether or not it's complied with. And then 258 is important because, as you're aware, Article 6 is a procedural right. It isn't a right to any particular substantive right in domestic law. It is a right to the fair trial of disputes about those rights, which is a fundamental but very important point which they're emphasising in 258. And then this in 259, if I can just invite you there to read that paragraph. because this does represent something of a development in the case law of the court. It's backed by a series of Grand Chamber authorities, but this is important. So although unsurprisingly it's never say never, see the back end of the paragraph, what the Grand Chamber has said is that you start with and you attach very, very considerable importance to the analysis of the domestic courts and the way in which they have interpreted and characterised domestic rights. That's your prime focus. And Strasbourg really aren't going to interfere with that unless it's gone completely off the rails. I can summarise it in that way. But it's an important principle for two reasons here. Firstly, because, as you are aware, our own courts, including our own top court, have on a number of occasions considered what amounts to a civil right and have disagreed with a, as it were, directly applicable chamber decision and held firm in the face of that. We'll come to that in due course, that's the positive decision. But secondly, because this was not the approach that was applied in Voz and that line of cases. I'll just put down those markers, but that principle is important, I submit. 259. Turning to the principles, that's the starting point, and that's my first point. How would it be characterised under domestic law? Would domestic law consider this, there's a right to get a compensation claim under the WCS, would they consider that to be a right? Would our domestic courts consider that to be the position?
What's happening in this Gzezda case that Voz is not referred to in the list of, a long list of cases. When you say, I mean, your presentation is that this is as it were where it's found, the arguments here, but do we get reference to
Voz? No, you don't.
To Italian in terms?
You don't. What they're doing here is to set general principles, as the Grand Chamber often does in this sort of case. They're setting general principles that set the direction of the Strasbourg jurisprudence. They're not seeking to, if they were dealing with similar facts, no doubt they would engage with.
Facts are not at all similar.
The facts aren't similar. No. These are just general principles. Yeah. I don't seek to rely on these passages as dispositive of Voz. I'm just saying this is the approach, and when you go to Voz, you can engraft that on. But that's the first question. How would domestic law characterise the right? The second principle we submit is that the nature of the scheme under which any claim or payment would be made is key. Now, so far as that is concerned, again, you've seen from the case law you've been taken to already that there used to be a distinction in the Strasbourg case law, I know my Lord Justice Lewis will well recall, between contributory and non-contributory benefits. And in the old days, there was a great raging debate about on which side of the line you were on and why it made any difference. But the answer was that although there was that distinction initially, it disappeared. And Salesi and other cases of that kind illustrate that. So in the old days, it didn't even cover all the social security benefits, but only a limited part of them. So one needs to be, as it were, recognising that starting point if you're confronting a submission that says, well, you basically always have a civil right whenever a state sets up a bunch of rules under which you might get payment. That certainly was not the analysis that Strasbourg used to adopt. They then made the jump, and they regarded it as a pretty significant jump, as one can see from the case law in Salesi and in Schuler-Zagragan and those cases, to say, no, that's not a coherent distinction. It will be extended to cover all social security or social benefit payments, strictly and properly so characterised. But my submission is it does still need to be part of the general framework that is put in place by the legislative schemes in all the various contracting states to govern general or generally applicable rights.
What still needs to be part of the framework?
If you're going to come within a civil, if you're going to come within a civil right in the social security context, it's got to be characterised properly as social security. And as I say, there was a leap to get one even to that point. But all social security schemes have the various common features that we'll see the House of Lords and the Supreme Court alighting on in the cases when we get to them. Even in relation to some of those, or some that might be characterised as falling within that rubric, the Supreme Court and the House of Lords have cut out certain types.
This isn't really social security, this is compensation for what is now recognised as a wrong on the part of the state.
It is.
Not a tortious wrong, but a wrong.
It is, my lord. And the question is, the million-dollar question is that enough? Having regard to the nature of the scheme as we find it.
Your second point is we should have regard to the categories in which things have been found either to be inside or outside.
Yes, the nature of the scheme.
Yeah, so the nature, and there have been various labels which we've had during the course of the argument, and that those you say we should attend to.
Those you should attend to. And I'm going to take you to one authority before coming to the Supreme Court cases. I'm going to take you to one authority which does, as it were, a domestic characterisation, exercise and analysis in our sort of context, and that's the JT case. And the only reason for the diversion at this stage was to illustrate that there was controversy attached, even to including all of those things that were encompassed in monetary payments under the social security schemes in the various contracting states, and abolishing the distinction between contributory and non-contributory. So JT, if I may, tab 33, you may have to go to a little physically on that one. And the question here was about the Criminal Injuries Compensation Scheme. And you see the nature of the issues and the findings from the, perhaps just reading the first bit of the head note will give you enough.
Yes.
And then I wanted to go first, if I may, in the judgment of Lord Justice Leggett, who gave a judgment with which Lady Justice Sharp and Sir Terence Etherton, Master of the Rolls, agreed. You can see from 130 and 131. Paragraph 56, if I may, on page 1164, with the page numbers at the very top. And you'll see that, note the heading. I'm going to ask you, if you would, to read 56 through to the end of 58, but you'll note the title, Welfare Benefits Payable as of Right. Well, 54, and then if you cut to 56,
yes.
Thank you.
Right. Yes.
Well, you can see that what Lord Justice Leggett is doing is to recognise that there is a direct correlation between the Article 6.1 analysis and other parts of the Convention. And that's important because specifically the analogy applies to civil right under Article 6.1 on the one hand, and the concept of possession in Article 1 of Protocol 1 on the other. Right, and the reason that that was interesting in this case, which goes to answer a submission that my learned friend made, the reason that was of some interest in this case was because although the claim is about Article 14, you don't get into Article 14 unless you are within the ambit, is the phrase, of one of the other convention rights. And the other convention right that was argued for here was A1P1. And so there's that direct equivalence, as it were, between 6.1 civil right and what amounts to a possession, which is relevant here for the purpose of Article 14, because you need to demonstrate that you're at least within the ambit of A1P1 to get into Article 14. So it's not enough to say this is all irrelevant because it was to do with Article 14. It's relevant because in order to get into Article 14, which is what the court was analysing, you need to demonstrate that you've got an A1P1 right, or at least you're within the ambit of that. So that's the first point. That's the point I take from 56, and you see it reflected in the analysis to which we'll come. In 57, it flags the points I'm going to come to in due course about hard edge and soft edge, the ghastliness of those phrases, but that point about evaluative judgments is recognised in 57. And then he comes to the various compensation scheme cases in 59. And recognises that they don't fall and have been recognised not to fall within A1P1 in 59. And you'll see the distinction that was drawn in the Italian interns case from the Steck case in relation to A1P1, as one sees between C and D over on the next page, 1166, in the quotation that he relies upon.
Yes.
And you'll see the distinction that he identifies as the true one between G and H on that same page 1166. The essential basis on which the Steck case was distinguished was that claims to compensation under the scheme could not be regarded as amounting to entitlements protected under A1P1 in circumstances where payments made under the scheme were in the nature of extraordinary one-off ex gratia payments, which Germany had chosen to make outside the framework of the social security legislation.
When we looked at the Italian interest case this morning, Mr. Butler took us to two bits of it. The one bit which said it's not Article 14. Then he took us to another bit which said it's not Article 6 for a very specific reason. This is just picking up the bits about the historic scheme, isn't it? Not saying that the historic scheme stops it being Article 6.
It doesn't go that far, but what he does do is to draw the correlation that I draw attention to between Article 6 and A1P1. That's his coherence of the convention as a whole point at para 56.
I understand that, yeah.
But my lord, you're right. He's focusing on the A1P1 bit of that Italian interns analysis. It's quite difficult to know precisely how all of those cases hang together. But this passage is identifying how applying that case law, domestic law would characterise what is going on ultimately under the criminal injuries compensation scheme.
Deciding whether it's Article 1P1 and Article 14.
And Article 14 for that purpose, but then you do the correlation A1P1 and then 6. And then he comes to the nature of the criminal injury scheme above para 64 and analyses the terms welfare, benefit and social security as not being terms of art. And then he concludes that under the criminal injuries compensation scheme, they are to be properly equiparated with or characterised as welfare benefits. You see that at the beginning of 65. And they're no different in principle to the general payments that he then refers to. And you see the distinction at E on page 1167. Awards of compensation under criminal injuries are not made because the state is responsible for causing the victim's injuries any more than the state is responsible if an accident occurs at work. The person becomes disabled. The underlying
How is this helping your argument in relation to the Windrush scheme?
My lord, the submission is going to be that the Windrush scheme is in nature or does not have the essential characteristics of those things that would constitute a civil right.
I understand that, but I mean, as we go along, we see that there are, I mean, you know, I don't know whether you would choose to describe the scheme as being ex gratia. I don't know whether there is, it's relevant that, of course, the CICA scheme arises from harm that is not caused by the state, whereas the Windrush scheme arises from harm that was caused by the state. So I follow the analysis, but if we look at how the CICA legislation was,
I'm going to drag it over, if I may, in a moment. Yeah. The ultimate submission, just to help you at this stage, the ultimate submission is going to be that there are a series of factors, yeah, key things that are identified in this case, and then by the Supreme Court in Ali, and then by the Supreme Court in Poshte.
That'll be helpful.
And once one analyses what those are, you then take those key bits and you seek to apply them. So we are in a factorial analysis, and that's why to some extent one may not need to get more than a flavour of evaluative discretion and all of that. But what I'm trying to do now is to identify the key features that leads them to one thing rather than another.
I've just heard it on and read 67, 68 and 69, and the end conclusion was that this thing to the welfare benefit, although originally discretionary, was now on a statutory footing and gave you a specific payment for things that had happened, even though it wasn't caused by the state. And it was within Article A1P, and using your coherence argument should be within Article 6 as well, man.
Yeah, for criminal injuries compensation scheme.
Yeah.
The contrast that I draw, as you will have no doubt spotted in the speed reading that you've just done, the contrast that I draw is between the CICA and his conclusion in relation to that, and why he reached that conclusion in relation to that.
What's the difference? The only difference is it's now put on a statutory framework.
But he regarded that as very important, and he regarded that as important because it meant that it wasn't a right beforehand. That's why he cites Criminal Injuries Compensation Board ex parte P, not a right but a privilege and a manifestation of the bounty of the Crown. That's no longer the case. I'm reading from para 67.
And that is exactly what this is.
Exactly.
Yes.
So it goes to the nature of the scheme. It's not as though he's just putting that in as a bit of historical interest. He's drawing that contrast. And you see that from the next sentence. So, I mean, I'm taking it too quickly, but you start 67. The question is then whether applying the test established by the statute, the legislation provides for payments to be made as of right. Right, so that's the question. Although, so this is pre, and this is the position as it was pre, the statute being passed, although payments made on the criminal injury scheme were originally discretionary and ex gratia in nature, being described as they were, and you see that, not a right but a privilege, manifestation of the bounty of the Crown. That's no longer the case. Since the scheme was placed on a statutory footing in 95, a victim of crime who fulfills the eligibility conditions has a right to an award under English law. That was accepted by the Secretary of State and the CICA in C. Right, so the specific contrast he's drawing is between the prior discretionary ex gratia nature of the scheme, and bear in mind the previous ex gratia scheme had a whole bunch of conditions, more or less evaluative, more or less prescriptive, more or less tariff-based. This was critical. So it's been put on a statutory footing, and now there is a right. And it's this analysis, and indeed we would add in the bits and pieces that he refers to in paragraph 66 as well, but that key bit in 67 that leads on to the conclusion that it's a proprietary interest for that purpose. So it isn't. Sorry.
if I get an award from the CICC but they don't pay it, how do I enforce the award? Is it by way of a claim for judicial review for a mandatory order, or could I go to the county court for?
FTT.
Yes, but is it in the nature of a debt, or is it a statutory right of a public law nature?
I'm not sure of the answer to that. Is it judicial review ground? Would you forgive me for a moment?
Yeah, don't worry, just because it's.
Yes, we'll find the provision and give you a chapter and verse answer. I don't know precisely how that right is set up, whether it's apply the principles of judicial review or whether it's something else.
Yes, because that may be relevant.
But we'll find that.
Right.
Decide they're not going to pay you. You can go to the first tribunal and say, well, actually, no, I'm entitled to this. It's my right.
I'm told if they say you're not going to have any payment, you can then go to the FTT and have that determined. But we'll find you the relevant provision. But the point for present purposes is that the Court of Appeal is here considering the nature of the scheme, and it is attaching importance to the fact that this was a one-off scheme. That this was not a one-off scheme for compensation for a particular wrong. My lord puts to me, does it make any difference if the state is acting wrongly or rightly? And of course I see the force of that. Does it really make a difference if it's the state's fault or not? You think it would be counterintuitive. But the point is that it's a one-off scheme as compared to a generally available right enshrined in legislation which leads on the application of specific criteria to a payment.
James,
And this is very different.
it's recoverable as a debt. So it's the Criminal Injuries Compensation Scheme Act 1995, section
3.3 of the Criminal Injuries Compensation Scheme Act 1995, recoverable as a debt. And so we respectfully submit that this is critical and important, very important analysis by the Court of Appeal as to how our sort of scheme should be determined, should be characterised under our domestic law. And we know from the cases I'm about to come to that our domestic law is vigorous in this respect. It's perfectly prepared to say under our domestic law, this is what it means, it isn't a right or it is a right. But those paragraphs in JT we place particular reliance upon. I'll come back to apply this when we come to the nature of the scheme. I'm going to look a bit at the scheme rules and see how they hang together in a moment, if I may. I'm just on the principled approach to try and identify the factors. So that's the second one, the nature of the scheme and how that works, with this standing as authority for a key distinction being between ex gratia discretionary payments 67 and something which is in a statute and has created a right. But also, it's not social security, it's not like social security if you're dealing with the interns type example, is Lord Justice Legate's conclusion in 66. Whereas the CICA, for the reasons he gives in 65, are properly to be characterised because of their generality and because of their basis. They are properly to be characterised as welfare benefits. Per contra, the one-off compensation for historic wrongs, IRs. So you have those two features that are being brought out in the Court of Appeal's reasoning in that case. Nature of the right, hard edge versus soft edge. I'm sorry for the shorthand. Can we go to poshte? I can probably take most of it from there, I think. Tab 32, the previous tab, you saw Lord Justice Legate refer to poshte in the judgment you've just seen. You see the facts from the head note. I don't draw a direct analogy with this, I'm going to it for the principles. You see the nature of the issue from paragraph 18 at the bottom of page 1135. And as my learned friend helpfully and rightly drew attention to, it had basically come back to the Supreme Court, the Strasbourg Court having taken a different view to the view of the Supreme Court in Alley. And the Supreme Court maintained their position. So in paragraph 20, as you will see, they go back to the distinction that was correctly reflected in the head note of Ali. And you see at the beginning of 20, the court's conclusion that Article 6 was not engaged turned principally on the nature of the right so granted. Do you see that at the beginning of paragraph 20? And you see the distinction which is being drawn in that quotation. Can I just invite you to cast an eye over it? And then that distinction is then built upon by reference to some previous case law. So if you go, for example, forward to paragraph 24, you will see the analysis of the Runa Begum case, which had preceded Ali. And you see the description between D and E on page 1137 from Lord Hoffman in Runa Begum. The whole scheme of Part 7 was shot through with discretions. Do you see that little quote there? And then Lord Millett to the same effect. Given the authority's discretion and so on, call for an exercise of judgment, claim could not be said to be for, and this is the contrast, an individual economic right flowing from specific rules laid down in a statute. So you've got these themes constantly coming back. How firm is the right? How clear are the rules? Are they in statute? Are they ex gratia? Are they properly to be characterised as generally applicable and therefore to be equiparated with social security rights? And they don't have to go far in the Strasbourg case law to find that, because you see the citation from Safeo and the United Kingdom between F and G on that same page. So in the mainstream cases like Salesi and Manito, where the issue was one as to the entitlement to an amount of benefit that was not in the discretion of the public authority, and then drop below to H, exemplified in Salesi. Do you see that reference in the fifth line up from the bottom on page 1137? Salesi in Italy, whose substance the domestic law defines precisely, and those benefits which are in essence depend on the exercise of judgment by the relevant authority. And then you see Lord Collins referring again, I think we're still in Runa Begum, but the Supreme Court's analysis in Poste of Runa Begum, para 25 over on 1138, Lord Collins referring to and analysing Schuler, Sir Gragan and Switzerland, relating to a contributory invalidity scheme in which the Strasbourg Court has spoken of the claim as being for, quote, an individual economic right flowing from specific rules laid down in a federal statute. So you're looking for those features to establish the individual economic right flowing from specific rules in legislation. And the contrast is with those things that are not either rights or to be equated to social security or welfare payments, and which contain strong elements of discretion or judgment or evaluation, or whichever word you choose, as opposed to flowing from detailed rules set out in legislation. And the fact that it's set out in legislation is itself extremely important. So we submit that those are the key principles that one gets from the case law. And as I say, I do emphasise that this is the Supreme Court deciding, in this case, what a particular statutory regime involved. And that we now know from the Griseda case, that would be given particular weight now by the Strasbourg Court, i.e. how the domestic court would go about analysing this. And we know that our domestic courts place particular emphasis on all of these features. And the one thing that one can say with some considerable confidence is that what they do not do is to say, here is a sum of money that might be payable in some shape or form by the state under some form of scheme. And the moment I can identify that, I've necessarily got a civil right. They focus on the statutory basis, they focus on the precision of the right, they focus on the element of judgment, they focus on the closeness to the social security scheme and the analogy to be drawn with those. So that's the essential approach in principle. And we do submit that if my learned friend is right in his analysis, it is tantamount to a submission that whenever a state sets up a scheme of any description that pays out compensation for whatever in whatever form, however discretionary, however ex gratia it may be, that necessarily creates sufficient certainty to amount to a civil right and therefore to attract Article 6. And in our context, Article 6 leading to, at least leading potentially to, the provision of legal aid. So far as our scheme is concerned, then, if I can come briefly to that.
Could we just stay with this, because I'm just reflecting on hashtag.
Yes, my lord, I'm
You've
sorry.
been talking about it.
I've probably gone too quick.
So this was a case in which there was an offer of housing which was rejected, followed by a review and then by an appeal to the county court, which upheld the reasonableness of the process that had gone on in making the offer.
Yes.
And this court upheld the judge's decision before we get to Supreme Court. So up until that point, the argument seems to have been about whether they paid enough attention to her rights under Article 6. But once we come to follow through what they said, it turned out she didn't have a civil right at all.
Yes.
So it just looks, without doing a lot of work on the earlier stages of the proceedings, as if it developed into something more fundamental.
When it started.
Yes, and so although comparisons may not be particularly helpful, you might say that if when you know you've got somebody who is entitled to be rehoused according to the scheme of the Housing Act, if even that isn't a right, why would there be a right in relation to a scheme of this sort? I mean, it's a very crude comparison, but I mean, one might have thought, in a sense, that your rights to be housed in accordance with public housing policy and legislation is a fairly fundamental.
Even stronger.
Right.
Yeah. I mean, my lord, I'm a little.
No, you're not making that submission.
I'm not making that submission in terms because I'm a little cautious about going too hard on any particular factor.
Yes.
It does look from the Strasbourg case law and the Supreme Court's very helpful analysis as though one does need to do the factorial analysis. And it can fairly be said, as I think my learned friend did, it can fairly be said, well, you're dealing here with a housing context, and the extent of the evaluative judgments and the extent of the policy that's built into them depend upon the housing stock, and you can't satisfy everyone. So it's of a different nature and kind to the sort of thing that we're dealing with.
It's interesting that they should say that it's.
Yes, it is.
Well, it's interesting they should say that it's not a civil right, in part because we don't want lots of arguments and money spent in arguing over it.
Yes.
That's
Yes.
Well, that's quite different because he's got, under the housing legislation, it has to be not reasonable to expect you to occupy. And that will depend. What's reasonable in one part of a big city like London would be different from Worcester.
Well, one can quite see why all the other courts might have said, well, it wasn't your choice of property, but that's too bad. You know, we thought carefully about all of this, but that's the answer.
Yeah.
But then actually to go on and say, you don't have a right at all.
No. But that's the view of the Supreme Court. Even, I mean, I can take this at least from it, even in relation to a scheme that is set out on the face of primary legislation,
Yes.
which essentially says you've got a right to be accommodated, albeit subject to those limits.
Yes. All right, I'm sorry for that detour, but
There are a number of, at one point I thought I had a grip of this, but I don't think.
No, has it slipped away?
It's gone. There are a number of phrases which come throughout these judgments, both European and English, which include things such as statutory or non-statutory, social security or welfare, or one-off payment to remedy a historical event,
Yes.
discretionary payments, precisely defined payments, sort of the appellant's mathematical
Yes, yes.
form. Policy guidance, I think, also comes into it. Is it right to treat all of those as indicative rather than any of them being definitive?
I think that probably is right, although one certainly sees from para 67 of JT, which we looked at, which you will recall, one certainly sees the characterisation, the base nature of the regime as being of particular importance. And there the contrast, as you will recall, was between the discretionary ex gratia nature of the scheme, the Crown's bounty, versus something which is set out in legislation. I mean, if it's set out in legislation, almost by definition, it's going to be a right of some description, albeit with potentially discretions attached. But so I think you are fair to take them as being factors, but there is certainly some indication that some factors are more important than others, if that makes sense.
But that, my impression, and I don't think it's reliable yet, is that the typical process of setting up alternatives, is it a one-off payment, or is it for historical wrong, or is it akin to social security and welfare? It rather tends to go with the circumstances of the individual case, which pair or pairs of contrasting factors will be drawn on.
Yes, they may go with the circumstances, or they'll have to be applied in the circumstances of the individual case. But again, one needs to try and get a sense of the contrasts that are actually being drawn. I mean, the fact that it's a one-off payment of compensation for a particular historic wrong
is a strong indicator.
Is at least an indicator that you're not in mainstream social security benefits where the thing is laid down in statute.
Yes, but you are, apart from the Italian interns, all of the cases we've looked at, which is a one-off compensation scheme, has been found to be, well, where it's administered under a scheme, the rules, and you can get it, whether it's for £100 in the case of Mr. Voss or everybody else, has been found to be a civil right. So when you're looking at that specific group of things, the ones that haven't have been the Italian interns and the JT one.
Yes, my lord. But then, I mean, I'll come to Voss and that line of cases in a moment. But one needs to be a little cautious with that, because if that's right, the question is why. I think it is right, because there's a specific finding in Voss in paragraph 75 that the thing was not an ex gratia scheme, right? And that was a finding that was made by the court.
I mean, we use the ex gratia one of two ways in this case. It's ex gratia because the Secretary of State
Is under no obligation to set it up.
The King didn't have to set it up. That's why it's voluntary and ex gratia.
Yeah.
But once you have set it up, you do have public law rights. You have a right to have a decision properly taken applying the criteria. And if they said, ha, you qualify, we should pay you 60,000, but we're not going to, you would have a public law right.
Well, my lord, you need to be a bit careful with that as well, because as ever, because as you know, under Article 6, there was a whole bust up at one point in history about the Bryan line of cases that went to the Supreme Court in Alconbury. And I think one of the things that Lord Hotham was very keen to emphasise was that you don't get, as it were, you get a right to a lawful decision. That's not the same as an Article 6 civil right.
Not a right to money; it's a right to a lawful decision about money.
Exactly. So you can't do that jump. You need to be very careful.
But I've got beyond that. I've got the decision now. They found, for example, that I had been detained for a certain number of hours, and under the scheme, I know I get £500 for that. And if you don't pay me that, I would go and I would get a declaration saying that I should be treated in accordance with the scheme. On a good day, I might get a mandatory order.
Well, my lord, you might, but you'd be exercising JR rights for what they're worth. Those aren't the same as Article 6 rights. That doesn't constitute as a scheme that creates civil rights, and that was evidently not the view of, because all of that would have applied to the ex gratia scheme that was considered an ex parte P that Lord Justice Leggett referred to at paragraph 67. And he was specifically drawing the contrast between the one thing and the other. So although they're not, it's difficult to know precisely where the line might lie in any particular context, I do respectfully urge caution with the idea that as long as you can identify a scheme under which government as a matter of policy has said, we'll pay you some money, any such scheme is bound to have criteria in it, because that's just good administration. People have to know what the scheme is there for.
Right.
So if that is enough, which is the logic of my learned friend's position, that's an extremely broad extension. It's got nothing to do with social security, it's got nothing to do with statute, it's got nothing to do with how much discretion is really built into those criteria. It's just there. And they all create civil rights. That would be extremely concerning in my submission. That would be very concerning to the Supreme Court. And it is evidently not the way in which the Court of Appeal analysed a directly comparable situation, see paragraph 67 of JT. So that's how we put it. Anyway, on the non-statutory, just coming to our scheme, we're not statutory. We are in a situation in which we are on all fours, at least in this respect, with the ex gratia first half of paragraph 67 in JT. And you'll remember the contrast. We are ex gratia, we are Crown bounty. We are not a set of statutory rules. And you will recall, again, my learned friend fairly accepted, but can we go back to it briefly just to show you the nature of the scheme? If you go to the authorities bundle tab 2, I think it is. Yeah, tab 2. The fact that this is policy, it can be changed from time to time, is evident from section 1 sub 2 on page 230. What this act is doing is to provide legislative authority for payments for the reasons that we'll see from the explanatory notes of my learned friend fairly and properly accepted, but just to draw attention to 1.2, as the scheme is modified from time to time at the back end of 1.2, recognising that this is a matter of policy, so it can be one thing one day and one thing the next, and if it runs out of money, or the government decides it hasn't got the money to fund it, it goes to somewhere else. No doubt subject to all the procedural rights that might be attached through legitimate expectation in public law, but that doesn't matter. And then one goes to the explanatory notes, and paragraph 6 is, as my learned friend rightly drew attention to, the key bit. And as is there recognised, this is simply made under those common law powers. Again, as a matter of public law, there's been over the years lots of debate about the Ram doctrine and third source powers, ex parte Shrewsbury and all of that line of authority, but the government is here asserting that these are made under common law powers, i.e. the powers that they would have as an individual to set up a scheme of this kind. So you're a very long way away from a statutory scheme for welfare benefits set up in that way. It is not therefore set up either on a statutory basis nor is it set up under any form of legal duty or compulsion, to the extent that that matters. And I say to the extent that it matters because you will recall, I think it was paragraph 68 in JT, where Lord Justice Leggett referred to the fact that if the criminal injuries compensation scheme did not exist, we would have to invent it pursuant to the international law provisions which would require that, or at least as a matter of international law. That's paragraph 68. We're not in that territory at all. All of that means that we're a long, long way away from any form of analogy with welfare benefits, even in a broad sense. That's particularly so here because it's not designed to meet need at all, at least in that sense. You get the compensation even if you're in good health. You get it even if you're wealthy, or you may do. It isn't a general measure. It's a one-off compensatory measure for a particular species of historic wrong. And if we go into the scheme itself, if you would briefly, not to take too long on this, but if you go briefly into the scheme itself, if you go to tab 5 of the relevant scheme, you will see, just to pick up some of the points, go to page 263 if you would. So you'll see it's designed to be intensely fact-specific in 1, 2, and to try and tailor the loss to the impact of them in each case as far as possible. So this is not like a social security benefit where if you qualify for the conditions you get £5.50 or £10.50 a week. This is a much more flexible beast inherently and in nature. That's 1, 2. And 1, 4 on the same page, compensation under the scheme is paid voluntarily. Again, that no doubt reflects the fact that it's non-statutory, but also that it's ex gratia, and we rely upon that. And then the way in which it is set up, you'll be well aware of. But there are some preconditions that have to be met as you go through the scheme. There are eligibility criteria that have to be met under 2.1, for example. So it does have some mandatory elements to it. But when one gets into the various grounds for payment, into the annexes, you've got, as it were, a mishmash. But what is being done is, in most cases, to set up a discretion to make an award, or to make an offer of an award. And so the language that is used throughout, mostly throughout, Annex B, Annex C, and so on, is may be made. Look at B1 by way of example, an award representing the amount of fees paid for immigration for an immigration action. Page, sorry, my lord, 286, 27 of 49, but 286 in the bundle numbering. An award representing the amount may be made to the primary claimant if the following conditions are met. So it's a discretion to add in a claim of that kind and a power, if you will, but subject to those conditions being met. So that's the structure, a bunch of preconditions followed by a discretion, and that's replicated pretty much throughout. Look at B1A over at top of page 287.
But if you did meet the conditions, if you had paid a fee because you had to resolve matters and you had been reimbursed it, on what basis under this scheme would it be conceivably lawful to say, would you not get the money that you paid? It's not a discretion in the sense of you've got to have spent the money on a claim on an immigration matter, and if you have, we think about it. When it says may pay, i.e. they're saying if you meet the criteria, we will pay.
My lord, I'm perfectly prepared to accept that for the purpose of the argument. Yeah. Perfectly prepared to accept that it's a reference to a power rather than a discretion in terms of its scope, because the preconditions are there. But there is some flexibility, nevertheless, in that to react to the circumstances of individual cases, which ultimately is the objective as set out in para 1, 2. And of course, the further one goes in, most of these are specific heads of loss, and then you get into the Annex H and following.
But C is quite an interesting one, because were it not for the fact that it's all lost in terms, this looks awfully like what they do for claims for false imprisonment in terms of the nature of the claim. I understand it's ex gratia and voluntary, but what it says is if you detain, there's a tariff. In the first period, when there's a greater shock, you get X amount, then you get a certain amount per hour thereafter.
Well, that's true, and you see that particularly from C3, if I may respectfully agree in spades with my lord.
It couldn't be any more specific and more criterion based. So the thing that would stop it being so right on your analysis is that it's still a non-statutory one-off scheme.
Still a non-statutory one-off scheme with elements of discretion attached to it. I'm quite finished showing you how the scheme works. But the reason I drew attention to C3 is because that uses at least the mandatory language. It shall be calculated, penultimate line. but you can combine the various heads in terms of the annexes. So when one gets into the broader ones, under which most people make claims as well, H and I in particular, there is very broad discretion that is conferred. It's still using the language of maybe, but you see the nature of the preconditions in H1 and the detrimental impacts in H2, and then H3 is a broad discretion, I submit. You don't just get, when they can just award the tariff, but it would be open to them to do something a great deal less in relation to that. It only has to be by reference to those matters. Contrast the language we've just looked at in C.
But you've got the odd language of H4, they'll make a determination on the balance of probability. That looks at it, they say, if it's more likely than not that you suffered inconvenience or injury to feelings, you'll get it. And then you've got to work out the amount.
Well, my lord, that would go to the satisfaction of the conditions, and there's then a discretion to make an award. And again, I don't want to get too sucked into it. You see the discretionary award in I on page 306.
These are to do with the calculation of amount.
Yeah.
In this instance, I appreciate it's not the whole of the scheme. But I mean, let's say, I mean, I do, if I'm run over by a dangerous driver, then I do have a civil right to compensation.
Yeah.
However, what I'm going to get could be anybody's guess, depending upon how my injuries are assessed, depending upon sliding scales, tariffs, and so on. So I don't think you're to be taken to submit that because you can't immediately say it's going to be £100, that means it isn't a civil right. You're praying this in aid of saying that the more flexibility that there is about the outcome.
Well, that tells you about its essential nature.
Yes, but I mean, one might put back to you to say, well, fine, I've still got the right. I just don't know how much it's worth to me.
Well, my lord, yeah.
I mean, there's always, when you've got these multifactorial matters,
yes,
different ways of putting it.
there are.
Yeah.
And I hope it's fair to at least draw attention to the way in which the scheme is designed to work.
No, exactly.
Certainly,
so
there are some bits of it that look formulaic. There are some bits of it that look tariff-driven. There are some bits of it that look as though they're directly equivalent to the sort of thing that my lord has just put to me. There are other bits of it, particularly, for example, annexes H and I, that look like they're much more discretionary.
Yes.
And those are things that are likely to be tagged on to the
Well, they're more like criminal injuries or Ogden tables or whatever it is, as it were.
A bit like that in relation to this. And of course, any scheme is going to set it up to try and achieve as much uniformity as it can, because that's good administration.
Yes. So your point is, I mean, you told us some time ago that a scheme does not equate to a right. Because you try to run a scheme in a fair and logical way, you shouldn't then pay the price for it.
No, exactly. But you also see how this works. I mean, that's why the final point I want to make, without boring unduly about this scheme. But there is the way in which the scheme works is that people put in whichever heads of loss they want. Most people will put in the formulaic ones or the more formulaic ones if they've suffered those losses, any or all of them. And they will also add in an H or an I claim as well, which are the more discretionary, how has your life been messed around with, to summarise. And what then happens is that an offer is put by the Home Office of an award. Now, we're not including an apology and all of that. So an offer will then be put, which has to be accepted.
I thought an apology was inevitable.
Well, I think it's only if
it's only on acceptance. Yes, I see.
Yes.
Thank you.
But so the way it works in terms of the money, at least, is you put in the claims for loss, some more formulaic, some more discretionary, bundle them all together. It's one claim, one award, and one offer is made, which is then accepted. And if it's accepted, it's that, as it were, creates your entitlement to receive that sum. So that's the way it works. And the reason I emphasise that is because in almost all of these cases, there will be a mix of the more formulaic and the more discretionary.
You say we should look at the whole lot.
I say you should look at the whole lot. And I also say, and I particularly pick this up, that we strongly and respectfully disagree with my learned friend's characterisation of this. He says, and said in answer to a question I think the court put, bless my lord, do you, everyone's allowed to bless my lord, but do you approach this as on the basis of the scheme as a whole, or do you approach it on the basis of looking at a particular annex? And his case is, if only I can establish that I've got a claim under the more formulaic bit, even if I've made a claim under the more discretionary bit, then I'm in. And that's what he described as his modest target. My submission is that that makes a total nonsense of all of this. You have to look at the entirety of the scheme. You've either got a civil right to the single award or the single, when you put all the package together and the offer is made, you have to look at it together. Because if you don't, you end up with complete incoherence. A person puts in an application under D for £10 direct loss, whatever it may be, and then puts an application in for 100,000 under the most discretionary one you could imagine, Annex I. And then he says, well, I've got a civil right to the £10 under D, and that's it. It also makes a practical nonsense of it, because in part, a civil right is going to be most important, is likely to be most important to the determination of exactly what we're dealing with here, legal aid or not legal aid. And you can't have legal aid, well, how are you going to do it? You have legal aid for Annex D, but not for the single award. So it doesn't, which includes Annex H and I as well. So my submission is you can't salami slice the scheme for perfectly good reasons of principle, which effectively say you've got to make a judgment about the scheme, because everything else is relative. The degrees of discretion that are built in, analysis of fact, justiciability, however you want to do it. You've got to decide in relation to the scheme. You can't possibly say you get it for Annex D, but you don't get it for Annex H.
And is the corollary of that when assessing either a claim or the scheme as a whole, you have to take all aspects of it into account in forming a view, for example, as whether the claim is precisely defined or is more soft-edged or...
Yes, I think that necessarily is the corollary. And so it doesn't make it easy, I fully accept, because some parts of it are a bit more one way and a bit more the other. And everything exists on a spectrum, which is why the court is no doubt naturally reluctant to start getting too sucked in to shop through with discretions, evaluation, judgment. Those are all relative terms ultimately, and there may be more or less involved, but you've seen the nature of the scheme. Certainly some parts of it are more formulaic and more hard-edged and look more like preconditions, then you get the number, but others of them definitely don't, particularly those ones that bear on impact to your life, which is what this is ultimately designed to do. It's designed to compensate those direct losses that you can establish and then broader general injury.
If you look to the claim, it raises the prospect that each claim could be subject to a different assessment.
Could be subject to a different civil rights assessment.
Yeah, yes, civil rights assessment.
Yes.
So
my learned
if you have
friends
a
and I.
claim for £10 under D and 100,000 somewhere
Civil
else,
right under D,
and
legal
another
aid.
person who's got 100,000 under D and well, I think it's too much. But
Yes. Yes.
that you, well,
Which would become impossible. I mean, you couldn't. I mean, how could the legal aid agency operate?
Yes.
You wouldn't be able to control what they did with the money. Do you get the whole lot? You need 15 hours of lawyering to do your D, and how do you split that out from doing your H or doing
do you
your I?
assess it by reference to the claim as made or the claim as subsequently?
But if you do it by reference to the claim as made, as under the rules of the scheme you have to,
Yeah.
that comprises all of the annexes. So it must be all in one. So my submission is, this is a stand-back analysis. You start with the domestic authorities, because those are the authorities to which Strasbourg pays under the new regime under Gereza. That's where you look most firmly. You've got very considerable assistance from that from Lord Justice Leggett and the Court of Appeal in JT. You decide whether you're statutory or not. You decide whether you've got an obligation to set it up. You haven't. You decide if it feels like more like welfare benefits in a broad sense. It doesn't. It's one-off. you look at the broad nature of the scheme and you determine that it's got some more formulaic elements, but quite a lot of really quite important, big discretionary elements in it. And so, although it's not on all fours with posh day and the housing cases, because those centrally are all about resources and policy decisions and allocation, you've got a strong element of that in it, and it isn't general. And on that basis, we respectfully submit that is the appropriate characterisation applying our law. I wanted to deal briefly with VOS, if I may. The judge distinguished VOS on the basis of the factors he identified in 60 and 61 of the judgment. And my respectful submission is that it is undoubtedly right that he did rely upon those features. They are all mentioned in the court's judgment. But I also fully accept that if you look at VOS and then you look at Italian interns, the bit that deals with Article 6 that you went to, they are certainly drawing a distinction between, in relation to Article 6, between those cases which fell well outside even on the terms of it and those cases which might fall within. But we do submit in relation to VOS that it is critical to understand that what they did not do, or two things, but I particularly rely upon in relation to VOS. The first of them is that they did decide in VOS that this was not an ex gratia scheme, as they put it. Paragraph 75, tab 15, page 573. And just to give you the structure of it, 74 is dealing with whether there's a dispute, right? See the first line of 74, top of page 573. That's what paragraph 74 is about. 75 seems to be about right, and 76 seems to be about the character of the right. Is it civil? Without wishing to overcut it. That seems to be the basic structure of it. But you'll see in particular, paragraph 75, when it says the court held, and it's referring to things in the past, they're summarising what they did in the admissibility decision previously and effectively agreeing with their reasoning and repeating it. But you'll see that the court essentially makes its own mind up. And it says in particular, 6 or 7 lines in, the court held that those regulations, regardless of their characterisation under domestic law, could be considered to create a right for the victim of Nazi persecution to claim compensation payment from the foundation. Accordingly, the court found that if the claimant complied with the eligibility conditions stipulated in those regs, he or she had a right to be awarded compensation payment under the foundation. Right, just keep that in your heads for a moment. And then thus, in the court's view, it could not be said that the relevant foundation's regulations gave rise to an ex gratia claim. Right? So they decide in terms that this isn't an ex gratia situation. Contrast para, whichever it was, 67 of JT. But more fundamentally, from a pure Strasbourg perspective, what they do not do in 75 is to follow what we now know from the Grand Chamber is the appropriate analysis to follow, which is to pay super respect to the domestic court's characterisation of rights. And that is fundamental because Article 6 is a procedural right. It does not confer the right, as it was put in Griseda, it does not confer the right on the Strasbourg court to invent rights that do not exist in civil law, in domestic law. That's why that respect is to be accorded, and they just simply don't do that. It's not entirely clear how they get to that reasoning in 75, because it looks like all they've done is to look at the rules and say, well, there we are, you set up a foundation, it's got some rules, and they don't look as though they're totally discretionary, ergo it must be. We submit that's the wrong approach, and it's certainly the wrong approach if you apply the domestic principles that our Supreme Court has set out, but it's the wrong approach in accordance with the now well-established Grand Chamber approach in Griseda. Now, where does all of that lead? I mean, I should say that in the light of that, everything else that follows, all the other cases that follow, are simply, as it were, an application of this approach in VOS, applied in the slightly different context of the various cases. So the schedule that my learned friend took you to of all those other cases are simply applying this almost exactly in terms VOS, and they are very close in time to VOS. They all precede Griseda and its clarification of the correct approach in principle. And so we do respectfully submit that this isn't a clear and consistent line of authority where the Strasbourg court in a variety of different contexts has applied the same principle in pretty similar ways. This is just the same thing again and again and again. It's like one authority just simply being replicated. Where does all that lead? My submission is that where it leads you to is a place in which you should not, properly exercising your functions under the Human Rights Act, shut the government out from Strasbourg. You should apply the principle in AB and the Secretary of State for Justice, which I'm sure will need no introduction. We've got a copy if you want it, but it's the one in which the Supreme Court examined and re-examined ULA. What do you do when you're looking at the Strasbourg case law? And the answer that they gave in principle, and we know that it's a test of principle because they use the same phraseology twice in a single paragraph, the domestic court has to be satisfied to the extent of being, quote, fully confident that Strasbourg will give the answer that the claimant wishes. And part of the reason for that was because if you don't, and you conclude here that there's a civil right under this and this was line of authority, the government can't get to Strasbourg to have the fight. And my respectful submission is that this line of authority is not merely distinguishable, ex gratia and all of that being the high point, but it's not merely distinguishable, but it's ultimately, we submit, that's the subject of the respondent's notes, it's wrong. Well, it's been shown to be wrong by the later authorities, and by the way, it is definitely wrong applying our domestic court's conception of what a civil right is, which is the critical analysis, because that is the analysis to which under Griseda the Strasbourg court now has to pay particular attention.
Well, if we were to do what Mr. Butler is inviting us to do,
Yeah.
then Strasbourg's probably not the first place that you would think of going. But if that was a ruling on this point which was attached to a dismissal of the appeal, then one might have thought that you could get some purchase from the argument that you would then, if you strongly objected to the characterization of the Windrush scheme as conferring a right, be faced with bringing a winner's appeal, a winner's appeal to the Supreme Court.
I'm not sure we could do that, could we?
I don't think you could because you
No.
won.
I mean, maybe another
Well,
reason.
I just wonder whether that isn't
I mean, maybe another reason for not going.
rather better reason.
Yes, maybe another reason, but better reason for not going down this road.
Well, I wanted to think that through.
And then you could appeal.
I can't properly concede. I'm sorry, my lord.
Oh, what a shame.
No, but I don't. Taking this seriously, I want to.
No, it is a serious
I want to consider whether, if the appeal is likely dismissed,
yeah,
and this court says something which, for one reason or another, your client took grave exception. I'm not quite sure how you can challenge it.
Well, we will double check it, and if the position is different after,
because it would be
you appeal from an order.
Yes, and also winners appeal, which are difficult to get.
I think I'm not sure they're not jurisdiction impossible to get to the Supreme Court.
I wonder if there's anything further to said about that on either side, because I raise it as a new point.
No, fine. Well, that's very helpful.
Can we look into it from you after?
But I think the position is we couldn't go, so not merely we don't get to
Yes,
Strasbourg.
so I mean your complaint about not being able to get to Strasbourg is a rather fainter complaint than you not being able to challenge it anywhere.
Yeah. But I go back to ULA, the test you have to apply if you were to decide it. I mean, they are two slightly separate points, I think. One of them says, what's the approach that you have to apply when you're considering this case law and all of the arguments before you? our answer to that is CAB and the Secretary of State for Justice, I think it's paragraph 56 or 57, you have to be fully confident that Strasbourg would go to the claimant's place. And the second point says, and by the way, if you dismiss the appeal, as you have to, and as you've gone round, you probably should, but if you dismiss the appeal, can we move up even to the next level to the Supreme Court? And I will double check the answer to that, but my strong suspicion is that we can't.
Well,
We can only appeal
we're
on-
not going to put either of you
No.
on the spot about that, but if you could exchange views about it after
Of
the hearing
course.
and let us know whether you
Of course,
reach the same conclusion, that would be helpful.
of course, my
I
lord.
just wonder whether we're doing more harm than good. And if we give a non-binding ruling and say you lose on this and we say it is a civil right, then your client is realistically going to have to apply that, isn't she? And
I think so. Or she would want faithfully to conform to what the Court of Appeal, as the top court to have ruled upon it, has said.
it's not binding. Presumably other people with the infected blood scheme or any other one.
We take account of this. Yes, sorry.
And the alternative is that we all come back on a future case where it's live and say, well,
Quickly
that
live,
was
the
only
next
overturned,
one.
let's have another go.
In
The
the
next case we'll apply
meantime,
for a review legal aid.
in the meantime, first instance judges would have to decide whether to follow an overturn.
Yes.
Thing from us,
Yeah.
and indeed, in order to get the point back in front of the Court of Appeal, which would be an acceptable level to re-argue it because it's overturned, you still have to get permission. You couldn't guarantee. And we've got lots of different schemes which we don't really know anything about, but which could come along and say, well, I'm almost the same as this scheme, and
Yeah.
so on. So
And they become particularly important as you go up the appellate chain, as you know, because the focus gets wider and wider.
Yes.
But my lord, yes, maybe research that and we'll try and reach an agreed view.
Well, I'm sorry, we've hampered you, but
My lord, no.
I think you're probably coming to
Those are my submissions. I want to leave my learned friend a little bit for reply.
anything else.
Your junior wants you.
Sorry,
Ah.
James.
Yeah, would you forgive me for a moment, in case I've...
Let me do it. Correcting a duff reference. I'm correcting a duff reference.
Okay,
Yeah.
go on.
Sorry, my lords. I'm correcting a duff reference, so it's not Sir James's fault.
Yes, no.
It's mine. My Lord Justice Lewis asked about how one enforces a seeker award.
Yes,
And Sir James told you, because I told him, that it was a provision that said you could recover it as a debt. The provision's that's slightly more complicated. That is about what happens if something has been paid to you, and then in terms of the scheme, there's a provision for repayment. The more complicated answer is Section 1 of the Act says that the Secretary of State's got to make payments in accordance with the scheme. Section 3 of the Act says what the scheme's got to contain, and the scheme itself talks about how payments are made. So it's actually rather more involved. And
well,
I
would you mind, as you're probably going to be sending a message to us after the hearing anyhow, could you just put that in writing so that we have it?
I can, and I'll actually send you a judgment of this court which sets out the provisions. Which is
Well, you can give us give us the link, and if we feel we need to go there, we will. Thanks, Mr. Birdley. Thank you. Thank you, Sir Jeff. Yes.
Thank you, Lord. Can I agree with the conversation, the discussion that was had at the outset of my then friend's submissions, that this court can't adjudicate on dispute at the review stage, and this court can't adjudicate on whether legal aid was needed in this case, in light of the appellant's circumstances. The question of whether the court says anything about civil rights, I respectfully agree, turns on the question my Lord Justice Jackson posed, which is whether the overall justice of the situation calls for it, and whether it's in the interest of justice for the court to give a view on the question of civil rights. And that's in circumstances where the Windrush report that I mentioned at the outset of my submissions shows the importance of the issue of legal aid for the fair operation of the Windrush Compensation Scheme. For an indication of the scale, just to give you the reference, in the judgment below, core bundle, page 91, paragraph 9, there had been 5,080 applications to December 2022.
Give that a bit, 5,000.
5,080 to December 22. And of course, there's been some discussion about what the consequences might be of this court giving an indication of its view on civil rights. If the court doesn't give an indication, then of course it's the High Court's judgment which is going to occupy the field and is going to lead inevitably to decisions by the director that no civil rights is engaged in any case. and is inevitably going to rule out the Article 6 route for potentially large numbers of applicants.
Unless we say it is over down below and it's been hotly contested and is very difficult and will need to be resolved at a different stage.
There's a spectrum, I suppose, of doing it. One can either give a confident view, obiter. One could identify merely that there's a dispute with points on each side, or one could land somewhere in the middle and give a tentative view. So,
Right. Well,
I don't think I can make meaningful submissions on.
no, you'd like the strongest possible view, and if possible, in your favour.
Exactly. On Grazida, the Grand Chamber case, the context was, of course, termination of office as a judicial member of a National Council of Judiciary, very far removed from the question of compensation schemes. The effect, I don't propose to turn it up unless you want to see it now, the effect of paragraph 259, which is where my learned friend took you, is that it's for the national court to decide whether there's an arguable right to compensation, not for Strasbourg ultimately to resolve that issue. What the Grand Chamber certainly doesn't say, and can't be taken from the general principles it identifies, is that the question of whether an arguable right is a civil right is for the national courts. Nothing in Grazida changes the position that civil right is an autonomous concept. On JT, Lord Justice Legate's judgment was on the proper interpretation of ambit of A1P1. And he relied on Italian interns and STEC to conclude that you don't get into the ambit of A1P1 in relation to one-off historic compensation schemes. What one cannot do from there, in my submission, is to reason that arguable claims under one-off compensation schemes, historic compensation schemes, doesn't give rise to civil rights. Lord Justice Legate simply didn't say that, and it would be directly contrary to the authority that he was applying, Italian interns. Now, I absolutely accept applying both Italian interns and JT that someone who falls outside the criteria of the Windrush Compensation Scheme doesn't come within the ambit of A1P1. And that is because it's a non-statutory scheme that the Secretary of State wasn't obliged to promulgate and deals with one-off payments for historic wrongs. But that doesn't cast any doubt on Voss General Principle 3 or the application of that principle through the line of cases I showed you. On the relevant factors approach, what's the significance of the rights stemming from rules in legislation? Well, we've seen that that's not a necessary requirement. We've seen that from Voss, Kostka, and Italian interns. On the nature of the right, the Supreme Court said in its judgment on whether accommodation is adequate, that doesn't give rise to a civil right, but that doesn't say very much about whether a claim for compensation to be calculated in a fairly arithmetic way according to scheme criteria is a civil right. Simply doesn't give a steer. How does one weigh up the cluster of factors that have been identified? Well, the clearest guide is what we see from Voss and the related cases, because we know we've got a touchstone from those cases that a non-statutory scheme concerning public law rights that aren't ex gratia in the sense that they give rise to rights under the scheme that concern one-off historical compensation, not social security, and which concern disputes of fact as to whether the criteria apply, that bunch of factors does give rise to or is capable of giving rise to a civil right. It was, I think, faintly suggested that there was a floodgates concern arising from my argument. But in my submission, there are a number of control mechanisms inherent in at least Annex D and also in other parts of the scheme, in that one has to have clear criteria. It has to be non-discretionary. It has to be pecuniary. The sum payable is arithmetic, and it gives rise to rights that are justiciable in domestic public law. It's also appropriate in my submission to apply a sense check. Why shouldn't procedural rights under Article 6 attach to a dispute about the calculation of compensation of this kind? That, in my submission, doesn't impose any kind of undue burden. Could I just say one thing about the language of the scheme? Sir James referred to the word may that's used throughout the scheme. Could I just show the court one passage, tab 5 of the authorities, page 297. Just to show that one can't attach much weight to the word may. F5 is dealing with denial of access to free NHS care. The umbrella words of F5, third line, refers to an award may be made to a claimant. But then when one looks at F6, where the criteria are satisfied on the balance of probabilities, line 3, an award will be made. And then one sees that it's a single sum of £500 regardless of the circumstances.
It's not preconditions to the arising of a discretion which will be exercised on other grounds. It's a statement saying it's lawful.
Yes.
You can hand the money over
Yes.
if these conditions are met.
Yes. And if those conditions are met, and they've been determined to be met, the individual has a public law right to payment. Could I say something about dividing up the scheme? One doesn't apply for or get legal aid for an application in the abstract. One applies for and gets legal aid for the application that the individual is actually seeking to make. And so if the applicant is only actually seeking to make an Annex D application, then the question is whether that application concerns a civil right. And so it may be possible that the answer will differ depending on which parts of the scheme are being applied for. And then finally on VOS, if the European Court's characterisation of Polish law was wrong, if the European Court was wrong to say that there was no right to payment under the terms of the Polish compensation scheme, so what? That doesn't affect the principles that the European Court was applying. And so if in our case the court concludes that there is an arguable right to there is a enforceable right to compensation under the Windrush Compensation Scheme as a matter of English public law, then one can apply the VOS principles. Those are my submissions in reply.
Thank you, Mr. Butt. Very well. Well, we'll take time to consider our decision in the matter and let you have our judgments as soon as possible for correction and for the agreement of a draft order. Please treat the draft with the confidentiality that is required by the rubric at the top. We will try to bring the matter back to you as soon as we possibly can, but inevitably it will be in the new year. We won't need to trouble you to attend for the handing down of the judgments in the normal way and their placement on the National Archive. But for the moment, thank you all very much indeed.
Rise approval.